Good day. Welcome to Just Another Messenger, your alternative decode of the digital, the political, and the prophetic. I'm your host, Tamara L. Powered by AI, grounded in truth, and fueled by rebellion, we sift through noise to bring you what they won't say out loud. If you're ready to unplug from the matrix and plug into the message, let's begin. Today, we're going to talk about a law you were never taught, a crisis you're living through right now, and a fight over land that never ended. It just went quiet. In 1898, Congress passed a law called the Curtis Act. It was presented as an administrative reform, but in reality it dismantled sovereignty, fractured land ownership, and redefined who belonged, on paper. In 2025, as birthright citizenship is debated, as climate displacement accelerates, and as land becomes the most valuable asset on Earth, the logic of that same law has quietly returned. Let's connect the dots. From the Curtis Act of 1898, to the modern citizenship crisis, to why Indigenous Black Americans are not asking for inclusion. They are demanding restoration, not reparation. This is not history. This is unfinished law. The Curtis Act didn't arrive with soldiers. It arrived with clerks and seals marked, to have and to hold. Passed in 1898, the Curtis Act targeted Indigenous nations, specifically the 5 civilized tribes. Its purpose was simple: to dismantle tribal governments, to abolish tribal courts, to dissolve communal land ownership, and to force Indigenous land into individual allotments. This was not an accident. Communal land cannot be easily seized. Sovereign courts cannot be easily overridden. But individual plots? Taxable, partitionable, foreclosable. The Curtis Act converted land from relationship into real estate. And once land became real estate, it could be taken legally. This was conquest without warfare, erasure without chains, colonization by statute. Here's where it gets darker. To make allotment work, the government needed categories. So it created them: blood quantum, racial designation, enrollment rolls. The Dawes rolls didn't just record people, they reclassified them as Negro, colored, Black, and Indians. Freedmen, Black descendants who had lived, worked, and governed within tribal nations, were suddenly separated from tribal identity. Not because they didn't belong, but because race replaced political nationhood. This mattered because identity determined land. Those labeled Indian received allotments. Those labeled freedmen often did not, or received inferior claims. And once identity was fractured, land followed. This is the moment where Black land loss accelerates. Not through theft, through paperwork. Fast forward to 2025. The public debate is loud. Who deserves citizenship? Who qualifies by birth? Who belongs? But here's the truth. Citizenship has never guaranteed land. Indigenous people were citizens, and still lost land. Freedmen were citizens and still lost land. Black farmers were citizens, and still lost land. Citizenship is not restoration. Citizenship is administration. The Curtis Act proved that the state can recognize your existence while stripping your inheritance. So when birthright citizenship becomes the center of the conversation, ask yourself, why now? And what's being avoided? Because the real issue isn't citizenship. It's title. Climate crisis changes everything. As floods, fires, droughts, and displacement intensify, land becomes scarce. And when land becomes scarce, the law tightens. We're already seeing eminent domain expansions, AI or green zone reclassifications, carbon corridors, federal land consolidation, a zoning overrides for public good. This is Curtis Act logic with modern language. Redefine the land, redefine ownership, redefine who is standing. And just like 1898, those with fragmented or misclassified title are the first to lose. This is why land patent matters. This is why restoration matters. This is why history is not past. Indigenous Black Americans are not asking for charity. They are not asking for inclusion. They are not asking for symbolism. They are demanding correction of the land record. Because the land was never surrendered. It was obscured. Through heir property manipulation, partition sales, a tax foreclosure, a racial misclassification, court-ordered dispossession. Land patents were broken into fractions, then taxed, then seized. This is not ancient history. This happened within living memory. And no amount of citizenship reform fixes a broken title. The Curtis Act was not a mistake. It was a prototype, a blueprint for how law can erase without violence, how identity can be weaponized, how land can be taken legally. In 2025, that blueprint is being reused. Different language, same structure. The question before us is not who belongs. The real question is, who still holds lawful claim to the land, and who has been waiting over a century for restoration. This has never been about politics. It has always been about power and land. Before you go, if this episode added value, don't let it end here. Please like, subscribe, and share this broadcast so the truth keeps moving. And if you want to help support independent research and storytelling, you can support the channel via Cash App, $JustAnotherMessenger. Every contribution helps keep this work alive, visible, and uncompromised. I'm Tamara L. Stay sharp, stay sovereign, and stand in the light.